waje no wafaya enti obobi ebewura mnaja ya mo kan nyina ewo eye Facebook live wano so e de abrayan na wanhu se obi antimi nyo obi bibia wa bra obi anyo obi bibia na Angel News rankasa wa wuji tumu so aha edi ho adanse ese we akwakwa ese ayi asante bekwai fo fene wo se eche kurei cheji dai esa che polo e de eka ho na ya to so amrahye bedwani ya wo gina mo e de ema akwatia eye honorable NS ya okumi mi gidi yesa mi bo ni din wo pe bia na sama kwa akoduru pa amanfo beka ya enkunim ya wodi ye ewo eye 2024 abato no emu no eho eba asem ema kofodua high court no kra no omo de contempt wo mo e de ere no ya na ama MP a wodie no na akwa ye bibia ewo ho na ene Supreme Court akọ eho asetena ama atemu obi afrimo aba eti ekọ eyenua ama brakon ampofo enchen ama mahai na boye enkomo
na mejo so ne na wo kanyina efa eye ononyamfo NSC akumi eho eye Akwatia mahye bedwani na kakra ni na Koforidua High Court ekọ asetena efese papa no wo court na ntia nti yede ye refer no contempt application editor ni so no na Koforidua High Court na eye otimafo amedeke eka ase da bi wo ye mahye bedwani wo di mahye bedwa ewo nkran aho na wakonwa sinemu ontimi fa court na nim ndwetwe fom nti omra na so twe bi ese ne fata no wonfa emo na ye beka se contempt no echen na de aka ni so beba na court na ka chen se ne ko de fiase se ye boso me se ye daba kwa na enam yenu eno ena ne lawyer eye lawyer garin ma ko te ye pe eni edimri kan ten eno bi pimu Supreme Court na se ahwefo ne tie so be kai krampa ononyamfo ya kumi ebra no wo mrahye bedwefie mo te se contempt application bi etintim na pe video bi ayehu ya na ye mahye bedwefie yehu ya ne se no wabonten opie ba inside tana se oba mahye bedwefie akonya ni mu ape eno befa ne nema tipa opie koi na nkofo bi sa se ene na watinti na wo dwane anase den ya no ene Supreme Court ko asetena ene na ya hyese ye de atemu ni beba ba no bedwe court na se na justice Gilbert Scott Kwaman wono ena na ye premu pani echese da bi su ene ban a Koforidua High Court no eda na di efa contempt application ne ho wentie ononyamfo NSC akumi asem kra enu achi kra san issue bench warrant say bebi ebehu ni bia ye mpɛ na nche no na ye mfa na mra court na court mfa na so twema no nkodem court ne se da bi oyesa na wotietia emransa na so de mra no akwanim kra dodo enam sa heso amene sa injunction application no ye baako contempt application no ye mienu na bench warrant application ni na court aboni nyina adi atoagu na emum asem na nkasa na da ho a echese ononyamfo ya kumi abato a ye to ye ebra ye gazette na ye ka se ma on so ani hu in anase ma speaker en so ani hu in a oso ani hu in eno de substantive case eguso da ho na no enene court na sa ka se onu nko back no nko disa asem ne nkankura enwie na emum ye ka wie dia otemuafo a eya medical ono na net asem so court ne chese asem no Koforidua ho na ebedi na emum so otemuafo on na asem ni so eni eno na lawyer ni a wo ginam ede ama NDC openi a ono ene owura NSC akumi kwa no se da bi owura NSC akumi wase control aye friend pedigree ede akyere court no esanse gazette ye gazette ye no nkata o de ba court no ase nokure bia enim wase ye no so enche o makobo CID for amane CID for eyen hwehwem kra ye betu nti na obi say ya injunction application contempt application na bench warrant na issue say Akwatia mahye bedwani nya na ye nche no ene Supreme Court abosanse ni nyina atoagua obetimi akoso aye na adwuma se mahye bedwani a o kinam e de ama adehia ewo Akwatia.
Oh, okay. Amanti before say ene asam no ebekoso na chasa honorable NSC akumi na ontimi nko parliament on
when you are not otimi ko parliament na na tie ne se esanse na sa injunction no eda ne so no na ye di kan ba Supreme Court ama Supreme Court atimuafo no edi kan aka se oma so sa ache na ye nkoti no emu Almost science so otimwafo ni dua mu sese mpo ye che ne ba ene nka ensese o sentence no enti no de na meka se e ya de Supreme Court no e di kaya so mu deda ama sa injunction e wo mu se na e wo ho na so na Supreme Court na so ma na enye dwuma enye sa de anka meka se ononyafo ya kumi ya che no kra de na Supreme Court asomu den say kosi say on this atemu we beba mo bi anche no mo bi anso emfa ne nkokot nka say yemfa na so twe contempt no eman eninti na onya ebere ekọ eye na hye bedwafie mu.
Okay. Amania yamfa NC na asampaten no a ewo ho ye wo se wo mo edie se ye gye no atum ne ya hye no ma no ebeba so ana emma so no dache bia wudi akire na no so ba yebesa ate won kanti yamfa NC na ye na wase ye nua ama brakon ampofo na ma ne bo na yate bie no
Supreme Court kwa asetena ene asema na ededwa so nyina Akwatia constituency epoye mantem owura NSC akumi na ne nsema da woni se papa be yi a anka wobi obechi ni bia wonfa ne nkoma aposifo nsa so ne mu pa ne Kofodua High Court na de na kosanse na contempt eda ne ti so ema court ne kwa anim issue bench warrant eno ena ne lawyer Gary ni makoma fudi mirikantente ebe PM ewo Supreme Court ese Supreme Court ne se Kofodua otemuafo a wotena adwa ne so ne nsem kanye ne su ene ne ban a wodadi ne nyina ede na de befet kyerese ompe ononyanfo NSC akumi asem kra sanse wantie na asem mpo eno se wasite ne contempt enam sa yeso ema Supreme Court ka se da bi Kofodua High Court sa contempt application ene bench warrant na wa issue no ya som twetwe nyabotere kosi se asem no ye beka awie eno enenam so ma ononyanfo NSC akumi na wotimi komra hye bedwafie mu nkakran sa enye sa de a wene nka by this time na wo bie mu dededa na Supreme Court ahye say wode na temu nyina beba ene ebre Supreme Court kwa asetan Supreme Court say sa injunction application bench warrant no ene contempt ni nyina wabo e de ato agu baabi eninti enkonkope ni baabi enyina na asem na nkasa ye di e wo Kofodua High Court ne de wamu nkoso na wumuni ewo ho na eno na lawyer ni a wogina mu edi ema NSC akumi ye ne di nkomo enchiemu sei eno de ba efa nsam a esi ye ewo court ne ho ene dey ononyanfo NSC akumi ene na lawyer for ena uhuwom ewo court na enye asemketwa kra ewo ho na lawyer ni ono begina mu edema NDC parliamentary candidate wono ena de sansem nyina ekopiem ewo court eka chensem dwofo se wono de kwa edu fufuro bi wo ho a womo akobo CID headquarters amane ese wosre pa womo nya hwehwemu mapa emfanfa nsem esanse wosusu se the friend perjury say wabetwa ntro wabedi akohwie e de ache court no ebiesi sanse gazette aye gazette enkrata no wo mutusu se ne ononyanfo NSC akumi e de ba court no wo se wo mu hu ba bia okofa edifia etiamra enti so timi ebetwa ntro ana se otimi bedi akohwie pa e de che Supreme Court dia na enkoye kra wo se eno so enche omo eye hwehwemu mapa na saposifo nya ye omo hwehwemu wie dia na esebia no ye bete ho asem e wo court ye ntie nsem a wode tuja.
So recall that we made a case against we told you at the last date that we had made a case against it with regards to the perjury and then the forgery, and that has a link with the Gazette, which has now been pronounced upon by the Supreme Court. And so we will pursue that matter. As I speak to you, the matter is with the CID. We are aware that they want to take the caution statement of the Member of Parliament, NSC. The duplicate copy has been sent to the Attorney General's Department. We await the advice from the Attorney General's Department. That matter, as I have always said, is distinct and separate from this, because if you submit a Gazette notification which is forged, which is fake, it is a purely criminal matter which will be pursued. So I can assure you that it's not over. In fact, that is even a more serious matter. And now that the Supreme Court, some way, somehow, has said that there was a valid Gazette that has to do with ours, it puts into question what they submitted. And so this ruling would assist the criminal case we are doing at with the Attorney General and then the Ghana Police and the CID. And so we will pursue it from here. and then they may have to explain where they got the Gazette notification now that the Supreme Court has declared what they had or they filed as void or as fraud, or let me put it as not original at this point. We will pursue where they got that from, because if you submit a document to the Supreme Court and the High Court, which document is not valid, it puts into question what the intention is. And so there is that issue or that suspected crime of forgery and perjury, and that is what we will pursue from here. And I can assure you that that matter would also be pursued.
The first of your case, 4-1 majority.
Okay, so yes, the Supreme Court has spoken, even though we are yet to get the reasoning behind it. But essentially what they are saying, it's not really a 4-1 majority decision with regards to the first one. You know, the petitioners or the applicant filed a few reliefs, I think about 5 of them, with regards to the substantive matter. The Supreme Court, by unanimous decision, dismissed the 2 reliefs out of the 5. And no, 3 reliefs, and then the 1, 2, 3, and then the 2 which essentially bordered on the contempt and prohibiting the judge from proceeding to hear the matter is what was greeted with a majority decision of 4-1. And so we await the decision, and then the reasoning, and we take it from there. The other matter also had 4 reliefs, 3 substantive reliefs, and then 1 which is the normal thing lawyers do, which is that any further orders. And that also the court dismissed 2, the first 2, and then granted unanimously the 3rd one. Which 3rd one also borders on the contempt, which the court, they were asking the court to vacate the ruling on the contempt, which the court actually obliged them and then granted seal. And so essentially, per what we heard from the Supreme Court, the petition stands, the matter would go on unabated, but essentially it is the contempt that had that decision of the 4-1 majority decision. So we will go back and then we await the reasoning, and then we will advise our clients on the next week. That notwithstanding, there is still a valid petition, which, because you recall that the thrust of their case was that there was no Gazette notification, and that has been the thrust of it. Today, the court has dismissed that application. Essentially, what the Supreme Court is saying is that there was actually a valid Gazette notification, and so there is still a petition, so to speak, a valid one against the NSCL. And so we will go back and then advise our client, but there is a valid petition against them. We will pursue.
And out a lawyer near our Nujamo Edema Penny our Nujamo NDC Edimu Ewa Akwatia Mashebe Jefimo non I disanse menina equipium ewa court. Nanuachi and Angel Cassia bo any ora NSCL Kumi ne lawyer and Sudin Komo Efa and Semno and Chemuse and our no so edibai.
The petition itself. On that, the court said that the judge, the learned trial court judge in Koforidua, can no longer sit on that matter because his conduct has shown that he should not be allowed to continue sitting on the matter. So even though we may go back to Koforidua, but he won't be the judge to sit on the substantive matter.
Thank you.
But our main contention at the Supreme Court was that the contempt, its hearing, it's the conviction subsequent to the contempt, the sentencing. If you remember, there were even attempts to have an Kumi arrested, Honorable MP. All has been quashed by the Supreme Court. So as we speak right now, Honorable NS Yakumi remains the MP of the good people of Akwatia. So the conviction, the bench warrant, if you would remember, there was a bench warrant issued by the High Court of Koforidua. It has been quashed as well.
No, I'm referring to the
bench warrant was stayed by the Supreme Court to abide the ruling today. So as at now, per the ruling of the Supreme Court today, no bench warrant exists. So everything has been quashed. He's a free man and he will continue his good work as an MP for the good people of Akwatia.
Any out a lawyer niba kwa wojinamu edema onunyam for NSCL Kumi nensam enono and the Supreme Court and as ansem when you naba into say omunina sign Koforidua High Court na ensam no de aka wo hono omaka kwatena se no medi ni kama pa said yes na efata. And
there was one on contempt which through the applicant Honorable NS Kumi filed a certiorari application to have the contempt and the conviction by the Koforidua Court quashed. You remember that, right?
Yeah.
So, by decision of 4-1 today, the Supreme Court has agreed with Counsel Nimakun and said that the contempt application, its hearing, and the subsequent conviction on it all has been quashed. So as we speak right now, Honorable Ernest Jakumi remains the MP, the elected and valid MP of the good people of Akwatia.
Thank you.